Join us every Wednesday for InFocus, a weekly talk show produced by the SKNIS Information Service, where we provide exclusives with key persons within the government and discuss pertinent, relevant, and interesting matters that affect us all. Tune in every Wednesday, live on ZIZ Radio and streamed live on Facebook at SKNIS Media and ZIZ Online. InFocus, your government, your business.
I'm Ian Richards. Welcome to InFocus, a weekly program where we zoom in on what's happening within and throughout the government, your government. On Tuesday, the Federal Parliament passed a suite of legislation associated with the regulation of cultivation, possession, and use of cannabis in St. Kitts and Nevis and the rights of the Rastafari community. Joining us today to help explain the new legislation and how it will impact you is the Attorney General, the Honorable Garth Wilkin. Stay with us as we delve into your government, your business. Thanks for staying with us. Allow me to introduce as well the Honorable Attorney General. Thank you, sir, for joining us today.
Thanks for having me, Ian.
And I first of all would like to say to the public that the Attorney General, the Honorable Garth Wilkin, we use the abbreviation in government as AG, and so that is how I will be referring to the Attorney General today, with your permission, of course.
Of course,
sir.
that's what most people call me.
Right.
No.
Okay, AG, so let's begin now and speak a bit about your role as Attorney General here for the government of St. Kitts and Nevis. What essentially does that mean?
Well, the Attorney General, by the Constitution, is the principal legal advisor to the government. Effectively, what that means in practice is that myself, as Attorney General, and the Attorney General's office, we are the advisors to Cabinet, we're the advisors to the ministries, and we also support administratively the operations of the Director of Public Prosecution's office, as well as crafting legislation by way of our Parliamentary Council, who work in the office of the Attorney General.
Mm-hmm. So you've essentially been on the job for 10 months now. What has the experience been like?
Interesting. I've learned a lot. It's opened my eyes to a lot of different things. It's always a wonderful feeling when your work translates into making people's lives better. So it's extremely rewarding. I think that is what is the slight difference in the private sector. Not everything you do makes a large group of people's life better. Yes, you help your clients, but when you create legislation and you defend lawsuits on behalf of the people of the country, it's a great feeling. And I think that's one of the best things I've taken from this job. And it's what drives me every day. You know, it is really, as I tell people openly, that this is the public service part of my life. Mm-hmm. So it's almost the second phase of it, because when I returned from law school, I prosecuted. I volunteered to prosecute while I was in private practice, because I felt that because the government had paid economic costs, which they do for all attorneys, I felt there was a need for me to give back. I thought I had a particular training and skill set to prosecute, so I did that for 3 years. And now this is the second phase of my public service in this high office.
Well, it's interesting, AG, as you referred to the scope of the work that you have as a public servant now as Attorney General. Is there pressure when drafting legislation to get it just right, to ensure that the will of the cabinet and what is in the best interest of the people comes forward?
Yes, always. I mean, you are taking legislation to the people, and we have a very diverse society, so you can't please everyone. So what you try to do is to create legislation that fixes the problem and takes into consideration all the views and you settle on what you believe is the right laws and the right regulations to accomplish the goal. Because at the end of the day, what legislation does is it either creates regulations for something or it corrects the ill that we see in society, because what are laws for? Laws are to prevent chaos. And that is why the rule of law is so important. And that's why we create laws, so that there's no chaos in our society and we can live in a harmonious society which respects the different views of others. But there's a framework that we could kind of commonly agree on. And that's what we try to do when we're drafting legislation.
And of course, it's buttressed by the Constitution.
Of course. All legislation should comply with the Constitution.
Okay. So you speak about drafting legislation. Walk us through a bit about how the process goes about in terms of drafting legislation.
Okay, so one of the first submissions that I made to Cabinet was the legislative agenda of the various ministries. Because as I said, the Attorney General's office, by way of the Parliamentary Council, is in charge of the legislative agenda. So you first have a legislative agenda, which the ones that I submitted maybe had around 50 proposed bills, some in the pipeline, some proposed. And then when you settle on preparing one, you first sit down in a room, the three of us. We have two parliamentary counsel and myself. I tend to get very active in the process. And we say, okay, we're tackling these three. So we first start reading. If it originated at the ministry level, we would look at the minutes. What is required? What does the ministry want to see in the legislation? We discuss if there are any other similar legislation in the region, throughout the Commonwealth, and then internationally. And then we kind of set timelines and say, okay, let us each look at different models. Let us look at the instructions from the ministry. Do we have any questions for the ministry? Do we need to go back and ask what exactly to clarify some of the instructions? We do all of that internally. And then once we have clarity on what we're trying to achieve, the team will then draft a working draft. And we just go through various iterations. If it's a matter that requires public consultation, then we go to the various stakeholders and say, okay, this is what is being proposed. What are your views? I'll give you an example with the good governance legislation, the anti-corruption bill. We send it out to a wide cross-section of the populace, the Bar Association, the Chamber of Industry and Commerce, SKNIS, the labor union, and the general public, so that we can get views. And when we were crafting that legislation, we got some very good opinions. And those opinions we took into consideration, helped to shape the final version.
So those opinions are taken in even before the bill goes to the cabinet for them to review?
Yes. It depends. If it doesn't make sense taking an opinion sometimes before you know if there's the political will through the cabinet to move. So some might be before, because if there's a clear mandate from the ministry that this needs to be done, then we do the consultation, then take it to cabinet for final decision. And sometimes we have to take it to cabinet for final decision, almost like an approval in principle, because that's what it would be if it's prior to consultation. We say, okay, is this something that the cabinet wants to proceed with now? And then, if yes, then we go into the consultation stage. So with the good governance transformation legislation, that's what we did. I brought the legislation, after meeting with the Integrity Commission, we had the amendments to the Integrity in Public Life Act. We then had the amendments to the Freedom of Information Act and the Anti-Corruption Act. So then after discussing that with the Integrity Commission, seeing what they wanted and what they wanted to see, then I went to Cabinet, got approval in principle, then did the consultation. After the consultation, brought back a final draft for then approval. So it depends on the type of legislation it is.
Okay. And so that draft, that of course it has to be introduced in Parliament, or basically the first reading. Yes, explain to us how that works.
Well, the first reading, typically, in the regular case, you have the first reading so that the public and members of Parliament who are not in Cabinet have an opportunity to see the legislation and know that this is going to be proceeded with. So you table it, give them an opportunity. When you go to the core of what a member of parliament is, an elected member of parliament is somebody elected by the people of a constituency to represent their interests. So ideally, if it goes there, they then go to their constituency, discuss it there, and they come back for the second reading, which involves the debate, so that the views of their persons that they represent can be reflected through them in Parliament.
And so there's a bit of a time between the first reading and the second reading, so that is to allow the consultation.
Yes, usually. There's some uncontroversial bills. So we've done 3 readings a couple times. Initially, the first sets of laws that we passed in last October were, for example, changing the minister responsible for a particular piece of legislation. Uncontroversial, so you could have the 3 readings at the same time. We also did that with respect to the Nevis Island administration matters, because those were matters that had to be resolved and were agreed upon by the opposition, who happens to be the government of the NIA and the government. So there was no need to go any further than that. We had already consulted and had internal discussions since September. And we tabled that, I believe it was in April or May, I can't remember exactly, somewhere around there. And you can do 3 readings because there's agreement on what it should be. They were not long bills, they were not complex bills, but they were necessary bills. So there was an urgency to it, as well as collaboration because of the NIA being affected, collaboration between the legal department of the NIA and the Attorney General's chambers. So we felt that we could go for 3 readings, but typically it should be 1 reading, digest, come back and debate.
AG, in terms of the involvement of stakeholders, which you referred to earlier, how is the feedback collected? Because say a bill is given the first reading, as you mentioned with the good governance suite that was recently passed, feedback is collected. How does the ministry collect that information based on the feedback from the different stakeholders?
Send it out by email. For example, with the good governance, I literally, myself, I sent the drafts to the various stakeholders, and I said, listen, we want your views by, I think initially it was November 30th, I think, and then we extended it because we only got a couple of responses, and then we extended it until into the new year, and then we got more responses. So you can do it that way. I mean, there's no particular legislated way that you can get feedback, but you can just send it out and give opportunity, a fair opportunity for people to digest and then provide their feedback.
Mm-hmm. And so the bill goes through its second and third reading primarily on at the same sitting?
Yes, because you debate. I mean, if there are controversial issues raised during the debate that require further reflection, then you could always delay the third reading.
Okay.
And you could even delay the committee stage, which is where you work out little kinks and little errors that you can rectify, like we did yesterday. Mm-hmm. If they were more complex, I mean, there were very few corrections to be made, but there's a suite of corrections to be made. Then you could always adjourn Parliament, come back, and then proceed that way.
And I have to ask you about the relationship that the government has with the opposition. There seems to be a different tone in Parliament. There seems to be greater cooperation in a constructive and a productive way. What's your insight there?
The answer to that is what was said by the member for number 11, Sir Jeffords. He said, we are opposition, but if we see legislation come into Parliament being brought by the government, and we believe it's good legislation, what is the point of opposing? So it isn't that we are sending this legislation to the opposition and saying, we want you to support. We are bringing the legislation, and because it's good legislation that benefits all of their constituents, then you can take the politics out of it for a little bit, and you could give your views like they did with the good governance. There were some different views. The NIA was slightly different because they were directly involved. But if you consider the cannabis related and the Rastafari related legislation, they just supported it. I mean, I've made public statements in Parliament very early on that our style of Parliament is going to be very different to the styles of Parliament in the past. Because at the end of the day, think about it from our perspective. if we are creating laws from the Attorney General's office, we want to create laws that should be accepted by most of the population. They represent a large part of the population. So you hope, and it feels good from our office perspective, to have the opposition support. You know what that means? That means we're doing a good job. That's what it means. So I don't necessarily see it as an issue. I mean, there's a slightly different dynamic because the opposition happens to be made up of members of the NIA. But at the end of the day, what they have said is, we will oppose when the opposition is needed, and we will support bills when they're good bills. And I can say we've brought some very good bills.
Good. And just to add as well, while the 3 members from the NIA that are, well,
two.
Actually be 2.
2, yeah, of the executive of the NIA.
Right, but also, of course, there are persons from St. Christopher number 7 here, and also for St. Christopher 5 as well. So that are not involved with the Nevis Island administration.
Yes,
right.
And they have and we the member for number 5 has actually supported a bill before. I can't remember
exactly. It was
exactly.
a church-related bill. I
yes,
remember there was
yes,
one.
yes, and seconded it.
He seconded it. Yes.
I mean, that's democracy. You fight when you need to fight. You do the politics when politics needs to be done. And when you come to do the people's business, you do the people's business.
Right. And AJ, talk to us just finally, quickly, in terms of the drafting of the bills. When does a legislation or a bill, when does it become law?
Okay, so you have the 3 readings. It is passed into law in the National Assembly, which means the National Assembly has accepted it. Then the National Assembly has to send it to the Governor General for assent. When or if and when the Governor General assents, then you have to send it to be gazetted. It becomes law when it is gazetted. And that is why one of the pieces of legislation that we brought earlier this year was the Official Gazette Act. So instead of having to go to the government printry and being made available, printed and be available to the public, when the website gazette.gov.kn comes into force, I'm hoping, we're working on it, I'm hoping within the next few weeks, because the Ministry of ICT is working on it. When it is posted on the website, that will be, based on that law, the time when it becomes law. So right now, the 4 bills which were passed are not yet actual law, but we are going to expedite their gazetting, hopefully by the end of business tomorrow.
And so as it stands, is it that when they're printed, they become law?
When they're available for the public to consume.
Right.
It's natural. You pass bills in the National Assembly. If people have to abide by laws, they should be able to access those laws. And what we're trying to do is give them an opportunity, because the internet is so widely used, to access those laws. And from the moment they can access those laws on gazette.gov.km, they will become law.
And of course, with it being online, then of course persons will have greater availability to it, which of course helps to promote the good governance agenda. And anybody, anywhere can go ahead and read it.
I mean, I would love for people to be interested in the laws. I mean, I got a call this morning from a colleague who said they hadn't listened to Parliament in a long time, and they listened to the whole Parliament yesterday while they were at work and when they came home. And they said they felt good to learn about the laws, because Parliament is the process of letting the people know what you're doing, on their behalf. So it should be widely listened to. It affects everyone.
And speaking of those bills, AG, we're going to take a quick break and we're going to come back and speak a bit more about those bills.
Sure.
In Focus, we'll be right back. Welcome back to InFocus. We continue our conversation with the Attorney General, the Honorable Garth Wilkin. AG, let's talk about now the cannabis-related suite of legislation that was passed in Parliament yesterday. How did this come about?
In August, One of the first tasks I got from the Prime Minister was to look into the Rastafari-related constitutional issues that arose from this Rasta and Kofa case, and to also rationalize the cannabis laws in St. Kitts and Nevis, because there was some uncertainty as to what was done. You heard about 5 trees, you heard about 56 grams, but a lot of people did not understand how it worked. So I got instructions very early on to rationalize, and we started the process.
Briefly, AJ, just explain to us a bit about the Ras Sankofa case. What essentially was it about?
Ras Sankofa Maccabee took the government to court and the Commissioner of Police to say that, one, he was improperly charged with offenses related to cannabis, and that his constitutional rights as a Rasta were infringed by there being no allowance in the law for possession or cultivation of cannabis. What the court ruled in his favor was that any law that says you cannot possess any amount of cannabis and you cannot cultivate any amount of cannabis breaches a citizen and a national's constitutional right to their freedom of conscience, belief, and religion, as well as their right to privacy. So what the court found was that the Drugs Act was not in compliance with the Constitution. The judge then said, because that is so, he was giving the National Assembly 90 days to rectify it. The National Assembly at that time, this was in 2019, proceeded to do some amendments, which did not go far enough in our view. And there was a Cannabis Act that was passed in 2020, but not brought into force. So when I got the instruction is we met, and we said, okay, let us see what the state of the law is. And I met with my team. They sent me all of the various amendments. I read through the case. I then read through the National Cannabis Commission report, which was issued in early 2019. And we said, okay, these are the gaps. How are we going to rectify this? And we started to look at legislation around the region, around the world. And it percolated. We were working on it bit by bit, piece by piece. And I proposed to them how we should do it, because Rasta is independent of cannabis. Cannabis is part of the practice of the religion. So firstly, we need to give Rasta the rights that were recognized by the courts and make them, kind of solidify them in law. And that's how we came up with the Rastafari Rights Recognition Bill. Then we said, okay, not just Rasta have a right to use, cultivate, possess cannabis. We have to respect the rights of everyone in relation to the freedom of privacy and the freedom of your conscience. So then we came up with the Freedom of Conscience Cannabis Bill, which allows persons to get a license to possess a small amount, cultivate 5 trees, and smoke in designated areas. We also then dealt with the smoking aspect of it, because we had received at the office many complaints that persons were smoking not just cannabis, but cigarettes and other things in public. It was affecting people's health, asthmatics, and so forth. So we said, okay, let us resolve that one time. If we're allowing cannabis to be smoked in public, we need to create legislation that allows there to be designated areas for the smoking to occur. And then we started to rationalize the amendments to the Drugs Act, which is the decriminalization generally, whether you use it for religious purposes or not. It is no longer something that's going to cause you to have a conviction and to be sent to prison because of being convicted for possession and cultivation.
Okay, AJ, so that basically is an overview of all of the 4 bills that were dealt with yesterday, but let's rewind a bit and go back to the Rastafari rights, because essentially that is where it all started.
Yes,
essentially.
that is the core.
So it was the Rastafari Rights Recognition Bill 2023, and you said that it dealt specifically with the rights of persons who are in the Rastafari community and their use, cultivation, etc. of cannabis at that time. Yes. So give us a breakdown in terms of some of the key points in that bill.
Okay. What that bill does, it allows Rastafari groups to register with the Ministry of Faith-Based Affairs. And once you register, you're entitled to a suite of tax and other concessions, similar to the concessions that are given to churches. So Rasta was recognized as a religion, so they are given the same rights that other religions get in our society, equal justice. Then, a registered group can also register their place of assembly. Right? A temple, some call it a temple, they have other terms for it, but your place of assembly. Once you register your place of assembly...
Does it have to be a structure?
No, it can be a farm. So you register your place of assembly with the Ministry of Faith-Based Affairs, and at that place of assembly, the Rastafari can cultivate, possess, otherwise deal with, and use cannabis for their sacrament and their spiritual upliftment and edification. That is the core of what that bill does. The third thing it does, because there was a concern raised by the Rastafari community, what if there are people who pretend to be Rasta to get those rights? And then so we put in provisions in place to create a criminal offense for you to fraudulently try to get those concessions by proclaiming to be a Rasta group when you're truly not.
So how would that be determined? Is there some sort of an investigation?
Well, there'll have to be fraud. It'll have to be plain fraud. I mean, you don't know what's in somebody's hat. A Rastafari doesn't have to have locks, right? So if a group comes together and they believe in the Rastafari tenets, but it would be if, for example, a group registered and they were not participating in any sacrament and they were just doing it for potential breaking of laws. Then the police can go and investigate, and if they got benefits, the court can then take away those benefits and they can be prosecuted under the legislation. But that is just an aside. It was to give Rastafari groups an opportunity to take advantage of incentives that are given to other religious groups in the country.
And how important is that, of course, because we are predominantly a Christian society, but it's important to point out, as it was done last week when the Minister of Tourism was here, the Honorable Marsha Henderson, that St. Kitts and Nevis, the population is becoming more diverse.
Yes.
And that, of course, means that there are some persons who will have differences in religion. And, of course, the Rastafari community has been among St. Kitts and Nevis ever since I was a child,
Yes.
Going back. So how important is it to recognize the different faith-based institutions and organizations that exist here in St. Kitts and Nevis and ensuring that they are afforded the same rights and protections as others?
They come to the Ministry of Faith-Based Affairs, and that is why it's styled that way. It's not. It used to be the Ministry of Ecclesiastical Affairs, but now it's the Ministry of Ecclesiastical and Faith-Based Affairs. So if you're a group and you feel that you deserve to get some sort of recognition or some access to government incentives to practice your religion, then you come to the ministry and make the case.
You mentioned that they can cultivate their cannabis. Are there restrictions or regulations placed around that? For instance, can they just grow it in the front yard of their place of assembly?
No. There are general responsibilities that apply to everyone that's allowed to cultivate now, because there's no allowance for personal cultivation of 5 trees. You have to do it in a secured place. So if, for example, you have a farm, you have an entrance to the farm, you should not be growing cannabis trees such that they hang over the front fence, so that a 14-year-old student can walk along the road and take off a piece of the plant and then use it. I mean, it's all about reason. There were some questions asked, what is a secured place? A lawyer that I know well messaged me this morning, what is a secured place, Garth? And I said, I mean, act within reason. And the police will be educated to act within reason as well. Naturally, if it's in your backyard, for example, surrounded by trees, not any and everybody. A lot of people might not want anybody to see that they have cannabis plants growing. So you can grow them in pots, on your balcony, on your porch. You could grow them, you could have a mini greenhouse somewhere in your house. But the point is, you have to be responsible when you cultivate, so that you don't have minors accessing it, you don't have persons who have the propensity to abuse substances, and also that they're not stolen. So you just act responsibly, and you will comply with the legislation.
And so the Freedom of Conscience Cannabis Bill 2023, now that expanded the rights, as you mentioned, not only limiting it to persons of the Rastafari community, but also somebody who may need to use cannabis for medical reasons.
No,
or for
that is not for medical. No, it is not recreational or medicinal. It is religious and freedom of conscience.
Right, so explain to us how that works.
Yes. So if you subscribe to a belief that believes that cannabis is a part of your sacrament and you use it for your spiritual upliftment, separate and apart from medicinal purposes, you can apply for a license, and that license will allow you to legally possess 2 ounces legally of cannabis, legally possess 0.5 ounces of cannabis resin, which is the oil, the concentrated oil, and also cultivate 5 trees in your personal premises, as well as take your cannabis to a designated smoking area at an event or a business place and partake in it there. So it is not recreational and it's not medicinal. The medicinal regime is separate under the Cannabis Act.
Right, I was just going to ask that question in terms of where would the medicinal aspect fall?
The medicinal aspect is under the Cannabis Act, which we are now building out, and we brought into force on 4/20 this year. The commission is being set up, they get in the office, and they're going to control the licensing. The medicinal cannabis, because it's the only regime that allows sale of cannabis, it is highly regulated. So the cultivators are regulated, the transportation persons are regulated, the doctors are licensed, the pharmacists, the dispensers are licensed, the persons who sell are licensed. So they control that whole regime for medicine. And I read in Parliament there's a list of around between 15 to 20 ways, I wouldn't call them illnesses, but things that can be used, cannabis can be used for treatment, that are listed in the bill. The doctors will be trained to give prescriptions. So you can get your prescription, for example, if you have seizures, right, or you suffer from post-traumatic stress disorder, anxiety. You can show up to a dispensary with your doctor-issued prescription, and you could purchase cannabis. And the quality of the cannabis will be controlled by the testing and scientific research within that infrastructure. So that is the monetization aspect of the cannabis. And that is a whole separate regime. What we did yesterday was more the personal right regime. That one is the industrial regime. So Rastafari groups who have their place of assembly, their farm, can also get a license, because one of the concessions that they have is that they can get a license under the medicinal cannabis regime free. So they'll be the first to participate in that money-making, that economic infrastructure. And that's what we're hoping.
Right. Now, AJ, let me just go back a bit, because you mentioned oils, you mentioned in terms of resins, in terms of cannabis-related products. What about hemp? I know, that, for instance, that there are some products that you can not, if you were to instance to import them, they're included in certain ingredients that customs do not allow in. But there are some persons who say that, well, a store at Port Zante may be able to offer that. How are you going to? Well,
the THC content is what has been kept as in the schedule for the act. Hemp is a little complicated. Let's talk about hemp cultivation first, as well as the products. Cultivation-wise, I am advised by the experts in agriculture that if you grow hemp in St. Kitts, it will take over the cannabis. So it is not a good idea to introduce hemp for mass growth, because it will turn, I don't know technical terms, but it will convert the cannabis, the chemical makeup of the cannabis plants, such that they will not have the chemical makeup that will be needed for the medicinal purposes. So there has to be a discussion as to whether hemp should come to St. Kitts or not. That's for the technical people to do. But in terms of the products now, all products that you wish to import, the CMO, Chief Medical Officer, can give you a license to import if they are for medicinal purposes. So if you want to import a CBD product, creams for your arthritis, and other products like that, you can go to the CMO, get a license, and then import those.
Talk to us about the importance of having persons, or should I say groups, coming to register. And the distinction I believe is that persons must understand that it's not targeting individuals, but it is more so groups, and it's a matter of, as you mentioned, having the operations, more or less the regulations that are existing for other organizations, associations that are within the faith-based community.
Yes.
Yes, it's the same thing, essentially.
Yes, it's groups. Churches are groups. There's actually the mover of the bill, the Deputy Prime Minister and Minister of Ecclesiastical and Faith-Based Affairs, said that in order for a church to be registered, they have to have a certain amount of people. But it's not just the government deciding that. That is what the Organization for Rastafarian Unity recommended, because they want to encourage cooperatives. So it is based on their requests to encourage cooperatives and the general principles that religious groups come together as groups to get the benefits that the government gave, the incentives, why the legislation was crafted that way.
And so we move now to the Smoking in Designated Areas Bill 2023, which of course would be a follow-on to the Freedom of Conscience Bill.
Yes.
Tell us a bit about that bill.
It's a public health bill. So we met with the Chief Medical Officer, and we took advice as to the public health issue caused by smoking generally. And there is a regional and international move to eliminate smoking as much as possible. However, you have the personal right to smoke, and now you have the freedom of conscience right to smoke cannabis in a public space. Because the constitutional right to practice your religion is not just in private. It actually specifically says to practice your religion in private and in public. So now you deal with that issue. So we go back to how you create bills. So then you say, okay, you meet with the CMO, there's a public health issue in St. Kitts and Nevis. It's also a societal issue, because I have received complaints that persons were smoking at children's sports days and so forth.
Even at funerals.
Yes, right? And not even downwind, blatantly, as was mentioned in Parliament yesterday by one of the members opposite. Persons blow smoke in your face without any concern. So that's an issue. That's an issue because there are people who are allergic to smoke, and there are asthmatics and other persons who just cannot deal with smoke. So how do you solve that problem from a societal perspective? How do you bring harmony? What you do is you create an area for persons who wish to smoke, and then you create a smoke-free area. So what the legislation does is, if you're a business place, you own a business, or you are having an event, you can apply to the Chief Medical Officer to have an area in your business or area in your event designated for smoking. And then the legislation also requires there to be signage and so forth. You get your license, you display it, and then persons who come to that establishment will know there's no smoking there unless you are in the designated area. And the CMO is issuing regulations. Actually, I have draft regulations in my inbox to review from the CMO as to what she will require. She also is going to consult with the Chief Fire Officer to determine, if you have a business place, how many fire extinguishers you have. Because once you have smoke, you have fire. Not all the time, because vapes are not fire. But you know, if you're allowing smoke, a smoking area, you must have something to prevent there being fires. So all of that will be done. You get your designated area, and persons who smoke can be in that area. They have their space. And you know, it's amazing when during the budget debates in December, I had mentioned during my debate as an aside, because I was getting numerous complaints for leading up to the carnival season that people were just smoking any and everywhere. And people didn't even want to go out because the smoke was just too much for them. So I mentioned that there's a ticket for you smoking in public that existed before. And a lot of the responses I got were, oh, AG, you're talking foolishness and so forth. People are showing out to smoke. But a lot of them were like, okay, AG, why don't we get our own area then? Some people don't drink when they go out. Some people just prefer to smoke. Can they have their own area? So that was one of the things that went into, that public feedback went into the creation of this legislation. And we felt, from a cabinet perspective, that this was the fairest approach. There was a young lady who went to the music festival a couple of years ago. I don't think it was last year. I'm not sure if it was last year or the one just before the pandemic. But she had to be taken out in an ambulance because she got an asthmatic attack. Right. Because there was, I don't know if it was a reggae performance and it was just smoke anywhere. That won't happen this year. Because at the music festival this year, the music festival is going to apply to the CMO, right? And if they get granted, right, I think they would get granted because they know what the laws are, then persons will be able to smoke in that area, and the police will not tolerate smoking outside of designated area. So that young lady can go and enjoy her music festival in the middle of the crowd without worry about getting an asthmatic attack.
And the age provision, I think, is very important. Again, last week when the Minister of Tourism was on the program, she mentioned, of course, that persons would have to show their IDs to enter that area, because you're trying to protect persons, the minors, from not being exposed to these type of things. I remember the Minister, and he's also the Minister responsible for youth empowerment, the Honorable Dr. Jeffrey Hanley, spoke about the importance of defining that age range.
Yes.
Tell us a bit about how the consideration came about.
Well, that goes back to the National Commission on Cannabis. National Commission on Cannabis went around the length and breadth of St. Kitts and Nevis and consulted with the people, had town hall meetings, had polls and so forth. And the majority of people wanted a change to the cannabis laws. And majority of people felt that at 18, you could make a decision for yourself, right? We, as a government, we have made a decision. We do not want minors, persons under 18, to be smoking or possessing cannabis. That is a fundamental principle we have, and the police will be aware of this. It can affect young minds while the brain is developing. If you're an adult, then you trigger your constitutional rights, and you make your decisions as an adult. That's a fundamental policy. So as the minister said, you don't need your ID to get into the music festival. You need your ID to get into the designated smoking area. Because in the designated smoking area, you can be, there will be, as it is a 420 friendly music festival, persons smoking cannabis. And we do not want minors exposed to secondhand smoke or to cannabis. That is why in the whole regime, we are clear. Do not allow minors to have access to the cannabis. If you're storing it in your home, keep it away from your children. Just like you keep dangerous objects away from your children, you can keep your cannabis away from your children. It's not that hard, right? You keep your trees away from the children, right? If you need to enclose them to keep it away, right? If you have older children, it's a little more difficult, but you can find ways, or you can educate your children. But at the end of the day, children are children. So you have to take the responsibility as the adult in the household to try to not allow. And if you are found by social services or the police to be reckless in terms of your cultivation, your possession, and you get warned, listen, we understand that your child is accessing your cannabis and taking it to school or using it. Then you could have your license revoked, or you can get a ticket, right? And if you're super reckless, you can be charged under the Act, because the Act requires the possession to be responsible possession. I want that to be clear. It is not just possession in your home. It's not just cultivation in your home. It is responsible possession. As the Prime Minister said yesterday during Parliament, we want there to be responsible use, responsible possession, and responsible cultivation of cannabis. That is the way we work this thing in a harmonized way, so we can protect our vulnerable persons, we can protect our minors.
AG, what do you say to the persons who would suggest that the cost of a ticket, because I believe it starts at $50, they say that is not enough of a penalty for someone to try to deter?
The ticket, you see, the ticket is really decriminalization. The member opposite yesterday made that point, and then when I explained, he said he understood. It's a very complex issue because you have international laws. You have international organizations that try to prevent there to be trade internationally illegally in cannabis, because it's still an illicit drug on the international sphere. So you cannot just, that is why it's difficult to just free up the herb. I mean, the ideal thing, free up the herb and let everybody be responsible. But we have international laws, that treaties that we're part of. We have international obligations. We don't want to be blacklisted. We also have banking issues. So to resolve that, a lot of countries, Jamaica, St. Vincent, Barbados, Belize, and other countries, Antigua and Barbuda, have decriminalized. so that it's not an offense. It's almost like a traffic ticket, like speeding. Speeding, you get a ticket. You don't get a conviction that will prevent you from getting a U.S. visa. So possession of small amounts of cannabis, cultivation of 5 trees, is a ticketable offense. So you're not going to get a conviction. You're not going to be able to not get your U.S. visa if you apply for it. You see? So the $50 is really part of the ticket regime. It's not really a penalty per se. The penalty now arises with the public smoking. The ticket under the Designated Smoking Designated Areas Act is $500. So if you smoke a cigarette not in a designated area in public, you could be ticketed $500. If you're smoking cannabis in public, not in the designated area, you could be ticketed $500. That's more of a penalty because there's a public health matter there. But when it comes to your cultivation in your home and so forth, I mean, I would recommend if you believe, if you're Rasta, or you subscribe to Rasta philosophies and you believe that cannabis is something you use for your spiritual upliftment and edification, you get your freedom of conscience card. And then you don't have to even worry about the ticket. But for everyone else, if you don't subscribe to that and you want to cultivate your 5 trees, there's just a risk that it will be ticketed. But at the end of the day, it changes the culture. Police are not going to be hunting you down for your cannabis. Just act responsibly, right? So there are 3 different regimes. There's religious use, freedom of conscience use, which involves the Rastafari. There's medicinal, which involves the industry of medicinal cannabis. And then there's decriminalization, which takes away the stigma of cannabis-related matters. And all the government wants the people to do, all we ask the people to do is be responsible.
AG, we normally would end the program at this time, but the conversation, there's still so much that we have to get to.
Yes.
So we're going to push it to an hour. So what we'll do is we're going to take a break and we'll be right back with more In Focus.
If you haven't done it as yet, please do it today. Subscribe to our YouTube page at SKNIS Media for regular updates, live coverage, and even more information on your government. While you're at it, like, share, and interact with our Facebook and Instagram pages at SKNIS Media and SKNIS Info.
Welcome back to In Focus, a special extended edition today, and we are speaking with the Attorney General, the Honorable Gas Wilkin, and we are discussing the recent suite of legislation of cannabis that was passed in the National Assembly on Tuesday. AG, let's go back to the designated spaces for smoking now, because I think, it is something that basically is going to come to the fore, especially with the St. Kitts Music Festival being a 420 friendly festival. There are some persons who would say, okay, there is a designated space where persons can smoke. And I think the point was made last week as well, too, and you would have referred to it earlier. It's not just cannabis, it includes cigarette, includes vapes, includes cigars, anything. So there are some persons who would argue that, well, okay, with the smoke and there's wind, the wind can carry the smoke anywhere. What's your response to that?
Well, when the CMO is designating the area, I mean, yes, wind can change, but it doesn't change just instantly like that. So you typically know which direction from the southeast the wind is blowing. So when the CMO is determining whether to allow an area to be designated for smoking, for example at Warner Park, naturally it has to be downwind from the crowd, otherwise you're defeating the whole purpose. So because there is the Chief Public Health Officer, which is the Chief Medical Officer, responsible for regulating, then you can avoid that issue. As I said, there can be wind changes. So if it's in an area which has wind changes normally, the CMO might say, no, you cannot get a designated smoking area. The CMO might say, well, you have to have an enclosed tent and proper extraction fans, for example.
And I think that's important. The fact is that if you apply for a license, there is no automatic that you will be given a license.
No.
It depends upon her judgment as a medical professional.
Exactly. So, for example, there are a couple of cigar lounges in St. Kitts, and I know there's one in Nevis. So to allow cigar smoke there, they will have to apply. But their whole business is that. So naturally, the CMO is, I would expect, is going to say, well, you need to prove to me you have extraction vans, right? And you have your proper signage so that any member of the public knows that when they come into this space, they come into a smoke area.
How do you respond to persons who would suggest that the designated smoking areas may encourage persons to smoke more?
Can there be any smoke than there is right now in St. Kitts and Nevis? I mean, everywhere I go, I see people smoking. But, I mean, we have to see what happens. As the Prime Minister said yesterday, as a medical doctor, he said there's no evidence that he has seen that creating designated smoking areas encourages persons to smoke. There might be some that argue, well, less people will now smoke, right? Mm-hmm. We will see. We have put things in place from the Ministry of Health perspective to deal with any potential uptick in smoking. My personal view is I don't think there could be any more smoking than there is right now, because everywhere I go, there's a lot of smoking. But what this does, it creates a smoke-free environment so people can enjoy themselves, the ones who do not want to be around smoke. And the ones who want to smoke can enjoy themselves as well.
Right. So let's move on, AJ, to the drugs prevention and abatement of the misuse and abuse of drugs. That also was the final bill that was passed yesterday. Tell us a bit about that.
Yeah, that is in relation to decriminalization. That is the act that was mentioned and sections were struck down by the court in the Rassa and Kofa case. So there were some amendments to it already. However, there was nothing that addressed the cultivation. So there was 5 trees was always said, but 5 trees wasn't in the law. So what we did, we kind of caressed it because we had to make exceptions for persons who have licenses from the Cannabis Authority, persons who have their license issued by the Ministry of Faith-Based Affairs, Freedom of Conscience license. The Rastafari places of assembly had to be exempted. Persons, in terms of possession, persons who have a license from the CMO to import CDB products had to be exempted. And then we introduced the 5 trees. So that amendment really was an expansion and a clarification of the decriminalization regime when it comes to cannabis cultivation and possession.
And that would also help law enforcement in terms of the guidelines?
Yes.
Okay. So, AJ, I know that there was a list of do's and don'ts that you presented yesterday, and if you could just very quickly go over some of them for the benefit of our viewers and listeners. And
I hope that the ZIZ will put it up on the screen one by one. Good. So, if we could go to the do's and don'ts, that'll be good. Perfect. As I said, with every right comes a responsibility. So there should be no undertaking of any task under the influence of cannabis if doing so would constitute negligence, professional malpractice, or professional misconduct. For example, you're working at a factory and you're dealing with sharp equipment on a line. Even if you're working on a line, you should not be under the influence of cannabis while you do that. Because if you were drunk and doing that, you could be found to be negligent. So you don't want to create any harm while you're under the influence. That's acting responsibly.
Right. And that will be harm to yourself or anyone else.
Yourself or anyone else,
right.
Yes. There's also what I mentioned earlier, where you cultivate. Do not cultivate in the front yard and the trees growing over the fence so that anybody could come and pick your trees. Do it responsibly. Do it in a secured place. If you do not have a secured yard, do it in your house or on your porch. So no cultivation of cannabis unless in a secured area within a private residence so as to prevent minors or persons vulnerable to substance abuse from accessing such plants or any other unauthorized access. So you don't make it easy for persons to steal your trees either, because you don't want children, minors, to have access. You don't want potential persons who are prone to substance abuse to have access, and you don't want persons to steal your trees. No persons should access cannabis, cultivate cannabis, or smoke cannabis if they're under 18. Adults only. And that is a fundamental principle of this government. No selling of cannabis unless licensed to do so by the Medicinal Cannabis Authority. As I said earlier, Ian, the medicinal regime is the monetary regime. Right? You should not be, now that you have, Ian, if you want to participate in ganja tea, for example, you can cultivate your 5 trees and pick your cannabis and use it for your tea. There will be no need for you to go out and purchase. No smoking of cannabis in a private residence that is used at any time to provide licensed childcare or other similar social services. Keep it away from daycares. Keep it away from schools. Right? Keep it away from places where children are. I think that's a fair request. Do not drive under the influence of cannabis. Just like you shouldn't drive under the influence of alcohol. It can numb your senses if you use too much, just like alcohol. So you are a danger to yourself and the general public if you're under the influence and you drive. So naturally this also flows as a responsibility. Also, this one is important. In the Drugs Act, it says that you should not smoke cannabis if you are within 300 feet of a school during school hours. So if you live close to Sandy Point, which I know it has a new name.
Charles E. Mills.
I know it as Sandy Point High School. If you're when school ends and you want to smoke, you smoke. But also, you should also smoke in a place that doesn't interfere with anyone else generally. For example, you have an elderly neighbor, right? You should try to, if you can't smoke on your balcony because the smoke is going into a 90-year-old's bedroom, you should be responsible and just go down the road and smoke somewhere where the smoke is not interfering with anyone. But the law specifically says do not smoke within 300 feet of a school during school hours. How you store, as I said earlier. No storing, handling, or otherwise keeping cannabis in such a manner as to allow minors or persons vulnerable to substance abuse to access the cannabis, and similarly to allow unauthorized access to cannabis. So, you don't just leave your cannabis on the kitchen counter and you have children in the house. You don't leave it on your porch when somebody could come on your porch and grab it and take it. So you just keep it, store it, handle it responsibly, even when in public. Oh, we went through all. Let me ask you a question, Ian, if you allow me to be an interviewer. What do you think about those responsibilities?
They're very practical at the end of the day. And I think, most of the things that we as adults have to do, it comes down to personal responsibility. I believe there was a conversation once that you cannot legislate personal responsibility.
Yes, it's difficult.
Yes. But, at the end of the day, there are rules and regulations, and in this case, legislation that guides us. And so persons, of course, should be made more aware of what the rights are and what the do's and the don'ts are, and that would lead me to the next question that I have for you, actually, is that this is a lot of information to take in.
Yes.
Where can the public, any individual at all, learn more about these type of regulations and the do's and the don'ts?
There was one commonality during our consultations. I met numerous times with the ORU, the Organization for Rastafarian Unity, and public education was a constant topic. You can make all the laws you want, but if the people don't understand how they work, then it's pointless. So what we decided to do from the Attorney General's office is to launch a public education campaign. Those boards that were posted just a little while ago, that's the start of the campaign. What we're going to do is we're going to launch a website. Hopefully this week, we're aiming for tomorrow, cannabisclarity.gov.kn, which will have frequently asked questions, all of the information you saw there. You'll be able to submit questions on that site if you have questions, and you will get answers. We're also going to launch social media pages so that the information gets out there, and we're going to do that over the next few months so that there's wide understanding, because it is a lot of information to process, and we understand that. And I believe that the whole idea and the way I operate as Attorney General is when the laws are passed, I summarize them on my social media so people can have an understanding. A lot of people have thanked me for that, because a lot of people, they pay attention to Parliament, but they don't understand, they don't go into the nitty-gritty. So I try to summarize it, bring it into a consumable package so that persons can understand how the laws work. And we are doing an extensive public education campaign. We have influencers on board. We have professional material, as you can see from the boards. We have an excellent website. I'm so excited. I'm very excited for that website to be launched in the next couple of days. and we're going to try to educate as much as possible. Educate, educate, educate.
Attorney General, the Honorable Garth Wilkin, we thank you so much for being with us today. We are out of time. So
Thank you for having me.
Right. And we certainly would like to thank you, viewers and listeners, for joining us for this edition of InFocus. Be sure to join us next week at the same place, at the same time. I'm Ian Richards.
Join us every Wednesday for InFocus, a weekly talk show produced by the SKNIS Information Service, where we provide exclusives with key persons within the government and discuss pertinent, relevant, and interesting matters that affect us all. Tune in every Wednesday, live on ZIZ Radio and streamed live on Facebook at SKNIS Media and ZIZ Online. InFocus, your government, your business.